Wisconsin's state constitution has been amended 151 times since it was ratified in 1848. But a flurry of those amendments have come in the past 15 years, and now 3 more are on the horizon and on the ballot for November. One of those would end the decades-old practice by governmental bodies and institutions to address systemic inequities faced by historically underutilized businesses, those owned by women and people of color. One organization that's working to inform voters about the impact of this proposed amendment is the League of Women Voters of Wisconsin. We're joined by Debra Cronmiller, Executive Director of the League of Women Voters. Thank you so much for being with us.
Thank you so much for having me.
We're going to spend some time talking about this proposed amendment so we can understand what the impact would be. But first, help us understand how we got to this point of basically creating law by amending the state constitution instead of passing laws to bring about change.
Well, I think long story short, the legislature has taken the route of doing constitutional amendments because they feared the gubernatorial veto. And in order to enact law in Wisconsin, the legislature has to pass a bill in both houses, and then it has to go to the governor's desk for signature. If the governor vetoes any piece of legislation, then it does not become law. And in the cases that we've seen in the last number of years where the legislature was really in favor of a certain action that they didn't think the governor would support, they took the route of taking the question straight to the people.
We're going to talk about this particular bill, and forgive me for looking down for a minute, but I do want to make sure that we're reading this correctly. The language that people are going to see on the proposed ballot really talks about banning state or local governments from discriminating against granting preferential treatment to individuals or groups on the basis of race, sex, color, ethnicity, or national origin in employment, at the public sector, education, contracting, or administration. What is the concern with that? Because at the heart of it says we're going to ban discrimination. Is it really banning discrimination?
Well, this is where there's a little bit of deception happening by the part of the administration here in Wisconsin. Is the discrimination by governmental entities is already illegal. So asking the question, kind of begging the answer that is, yeah, that's right, that we should prohibit that, correct? It's like, yep, that is correct, because that's the law. That is at the federal level and the state level, guaranteed in our Constitution. We are not going to discriminate. What this does, though, is it creates an additional caveat, and that is that we're not even going to allow preferential treatment. And preferential treatment, in other words, more plain language for our listeners, that means initiatives that might have been put in place to help equalize discrepancies that have happened, inequities that have happened. For instance, we know there are many organizations right now, government and public or private organizations, that try to equalize health outcomes for all people, because we recognize that some individuals in the state of Wisconsin, particularly Black women, Black infants, have higher rates of morbidity in the childbirth process than their white counterparts. So this is something that we should equalize. We need more resources. We need to understand why. We need to help overcome those discrepancies so that we do get, kind of an equal treatment of all women in the healthcare system. And then therefore they would get equal outcomes, a thing that we're not getting right now. Under this law, those measures, those initiatives would become illegal. We would not be able to do that, equalizing. And that is, in our opinion at the League, one of the greatest injustices, not just to women, but to people of color, to immigrants, this is going to have very far-reaching and negative impacts for Wisconsin.
So let me try to put that in language that might be a little clearer. There are programs now that exist in Wisconsin where the state helps to fund programs that cause fewer women and babies to die. But
Right.
under this legislation, because that targets certain racial groups, it's gone.
Yes, it could be. Now, we've seen in other states where this same type of legislation has been enacted, that some programs do get targeted, some programs do not get targeted. And it's up really to the courts and to the lawmakers to decide how the law will be applied. And that too is a a risk that an organization like the League of Women Voters does not want to take. It shouldn't matter who we elect because everyone should be working for all citizens in the state who are our representatives. And I think this particular piece of legislation, if enacted, would create more disparities than it would in its on its face. What it's trying to eliminate are these discrepancies. But these discrepancies are the equity-based programs that we've put in place over the last 60 years to make the playing field equal. In the case of like Title IX programs for young students in Wisconsin, female students to have equal opportunity for athletics, for educational programming. That's a targeted group. We're targeting women. So based on the sex of the group that's being targeted,
Right.
that program could go away.
The other thing that's interesting is that the ballot measure says one thing, but if you actually take a look at the language behind the ballot measure, it goes into a lot more detail that people just don't see, know, or understand just looking at the ballot question itself.
Yeah. And I think they do try to create the ballot in a readable form, although I think we all agree that they could make it even more readable and more clear. We've struggled with this the last number of constitutional amendment questions on ballots, is that the actual change, the language changed or added to the Constitution is not the same language that we see on our ballot. And so maybe if voters saw the actual language that was being proposed to make that change in the Constitution, their answer to the question might be different.
So, what can we do as voters then, as citizens, to make sure that we have an understanding of what is actually behind the ballot measure and not the brief language that we get, which may be at best unclear, but could be misleading?
Yes. And I do think in this particular amendment question, it is misleading because it starts with that premise of should discrimination be illegal? It's like, yes, because it already is. And what it doesn't emphasize is the true impact of eliminating equity-based programming. And the government is involved with a lot of equity-based programming. We've had many instances in our history in Wisconsin where there's been systemic inequity. And in order to counteract that, we do have to be proactive. If we want more women-owned businesses to be part of the group of businesses that are marketed by the state of Wisconsin and our Department of Workforce, well, let's give them preference, because in having never given them preference in the past, there's a huge discrepancy between male-owned businesses that are utilized in government contracting and female-owned businesses that are utilized in government contracting. So if we want to be purposeful about trying to equalize that scale, we do have to create some incentives. And that's what, minority contracting, women-led contracting incentives have done in the state of Wisconsin. But those would be on the chopping block potentially if this amendment passes.
Deborah, thanks so much for bringing this amendment, proposed amendment, to our attention, to the attention of our viewers. And you can get more information on the League of Women Voters' concerns about this amendment, and you can actually see the language that would be added to the Wisconsin Constitution just by visiting their website. Deborah, again, thanks so much for being with us.
Thank you for having me, Denise. Thank you.